I'm going live simultaneously on Facebook and on Instagram so that everybody can see and hear this because this is important. So, the September 2023 newsletter for the BACB, in that newsletter, they published at the bottom of page 5 a section that says free speech and the BACB ethics requirements. Recently, individuals certified by the BACB have been involved in concerning discussions on social media. Not social media, podcasts, but okay, fine. This has led some to wonder whether making repugnant or controversial public statements constitutes a violation of the BACB's ethics requirements. The following activities are not typically accountable by the BACB due to the U.S. First Amendment rights that supersede the BACB's authority: opinion statements, parodies, hypothetical discussions. While we appreciate the concerns about controversial speech and might share these concerns in some cases, the BACB cannot be an avenue to redress unless the speech includes a violation of clients' rights, the law, or the BACB's ethics requirements. So, here's an interesting thing for you. I have a master's degree with emphasis in administration for education. Masters of Education. There we go, words. I can do them. It's late. And one of the requirements that I had to be able to get my master's degree was to do an employment law course. And a major portion of this course involved reviewing case law about free speech. And it wasn't just education case law, although it did pertain to governmental organizations, because, public schools, but it also covered case law for a variety of things. So I had quite a few notes from my classes, and also on top of that, I did a little bit of research. So I have a bit of a summary of things written up, so forgive me if I do a little skipping around, but I'm going to go ahead and read through some of my notes. So first off, the First Amendment for the United States guarantees, among other things, the right to free speech. This right has been interpreted and applied in a myriad of ways in different contexts, leading to a complex body of law that balances the rights of the individuals to express their view and the interests of societies and organizations to maintain order, respect, and safety. One area where this balance is particularly challenging is in the context of employment and professional licensure. In these contexts, the right to free speech is often misunderstood, with much assuming that all speech is protected without consequence. However, this is not the case. There are numerous instances where harmful speech in employment situations, private relationships, and professional settings may have consequences, and these consequences have been upheld as constitutional. For example, Friedman and Stricker. So, first off, the First Amendment does not protect free speech absolutely, especially in the context of employment. So, in the employment setting, employers' interest often must be balanced against the employee's right to free speech. One of the foundational cases for this context is Pickering versus Board of Education. The code for that is 391 U.S. 563, which was ruled on in 1968. In this case, the Supreme Court held that a public employee's statements on the matter of public concern could not serve as a basis for dismissal unless the statements impeded the employee's ability to perform their duties or disrupt a workplace. This case set precedents for balancing the employee's right to free speech against the employer's interests to maintain an efficient, effective workplace. Okay, so that's workplace. We're not talking about workplace, though, right now. We're talking about professional licensure. So, similar tensions exist in the context of professional licensure. In the case of the BACB and other professional organizations, they have established codes of ethics that include restrictions on harmful speech. Literally, we have that in our ethics code. While these restrictions may seem to limit free speech, they're often found to be constitutional. One seminal case in this context is Gentile, Gentile versus State Bar of Nevada, the court case code is 501 US 1030 in 1991. In this case, the Supreme Court upheld restrictions on the attorney's speech that could adversely affect the fairness of a pending trial. The court recognized that the restrictions were narrowly tailored to serve the state's interest in maintaining the integrity of legal profession and ensure fair trials. Okay, so there are multiple myriad other case law to consider in this context, because there is no carte blanche, you can say whatever you want without consequences. Another important case to consider that actually goes in the opposite direction, because it's important to understand that you can't control all speech, is the case of NLRB versus Pier 60 LLC, which provide an example of how courts are beginning to address the issue of relating to social media and free speech, specifically relating to offensive language and reporting issues that are going on in the workplace. So in this particular case, an employee used offensive language on Facebook criticizing his superior. He was subsequently fired. However, the court overruled the ruling, the firing, ruling that the post was protected concerning activity under the National Labor Restrictions Act, as it involves discussions about workplace conditions. So that particular case actually indicated that there is free speech, and it's not restricted 100% across the board. So, for example, my criticism of the BACB in this circumstance, where I am very clearly and specifically saying that the BACB are being ethical cowards by refusing to enforce our own ethics code, is free speech. It's protected. I am protected in my ability to criticize the BACB. And we all are. Okay? But there is there's no absolute carte blanche right for saying whatever you want without consequences. And in the case of the behavior analysts who had a very serious conversation about people being killed or sent to mass incarceration, so they had a conversation about genocide and mass incarceration, that was a case that was putting the people that we serve and their rights at a lower priority than their willingness to have this conversation. And there's a lot of issues with that. And the BACB is willing to lose their minds if we use the RBT or BCBA or BCABA logo on a shirt, or heaven forbid in a social media profile or an email. Like they're willing to do all their stuff to protect the integrity of the brand, their copyright material, their registered trademark, whatever you want to call it. I think it's registered trademark. They're willing to take issue with that because they don't want to devalue the certification. Well, my argument is that this does more to devalue the certification, allowing this sort of behavior to happen. Now, here's the thing. I have been clear from the very get-go that I don't think that those BCBAs should have their licensure pulled. I think that there should be professional consequences, and one of those professional consequences should be requirement for mentorship, which this sort of thing has happened before. The BACB has done this sort of thing in the past, where when there's inappropriate behavior, instead of licensure being pulled, it's more of a matter of, okay, we're a field, we're about improving, we're about making sure that we can grow and we can learn. This is behavior. So I feel like it would be very appropriate for those BCBAs to be required, if they want to maintain their licensure, to receive mentorship from disabled behavior analysts. And also maybe possibly get some mentorship from other disabled populations as well, because this is an ethics issue. This is a behavior. And we need to make sure our field is psychologically safe. And right now, the problem that we have in our field is that we're not psychologically safe. Right now, we're in a place where people are scared because if they screw up or they make a mistake, they're worried that someone's going to jump down their throat. You know what? Here's the thing. The criticisms that the other side, big air quotes there for you, has regarding cancel culture is correct. They are right to have that concern, because we can't have a community of practice if the response is going to be to try to get people canceled, lose their jobs, and hurt. That's unacceptable unless there's very specific paths that are followed. And in this particular case, me and others are advocating for mentorship and making sure that those BCBAs understand the severity of their behavior and how that impacts the people that we serve. Just so you know, in case that podcast has been taken down, or in case you don't want to have to watch or listen to it, because it's a very hard watch/listen. I think it's not a watch. I think it's just a listen. Sorry. Just so you know, the conclusion that they made was that mass incarceration or genocide was probably not acceptable because at least they're being useful to our society by giving us jobs. That was the conclusion. And there was a lot of problematic behavior throughout the entire podcast. But that conclusion right there is very concerning. Because when we have behavior analysts in our field advocating or having serious conversations like this, that's unacceptable. I understand if a 14, 15, 16-year-old is having this conversation because they're learning, they're growing, and they don't know any better. I understand if this conversation were had in the context of an ethics class and we were having a serious discussion about looking at the impact culturally of taking this approach. I understand that context. But the context of this podcast and how it was discussed and how the information was considered and presented is a clear violation of our ethics code, at least in one respect. And the BACB abdicating their responsibility because they don't want to do the work is very telling to me. It also is telling because while I have been very vocal about ABAI and their support of Judge Rotenberg Center passively, I haven't said a whole lot about the BACB's passive support of Judge Rotenberg Center. Here's the thing. The BCBAs and BCBADs at Judge Rotenberg Center, their certificates. The BCBAs and BCBAs at Judge Rotenberg Center, and I'm guessing they probably have RBTs working there too, okay? They're certificates, and they're ethically responsible, just like we're ethically responsible. And even if we were to just look at the contingent electric shock, looking at the court documents relating to contingent electric skin shock and the use of it, looking at those documents that have been released through the FDA's investigation and other court cases, it's clear that Judge Rotenberg Center is not following our ethics code consistently, and that the use of contingent electric skin shock is a violation of our ethics code. And the BACB has still done nothing about it. That's just considering that context by itself. That's it. However, there's more. If you read the book Pain and Shock in America, if you look and do your own research into Judge Rotenberg Center and all the other ethical issues, everything from the deaths that have taken place to the many police reports to the latest report that has happened that's come out recently talking about very concerning behaviors that are occurring under the watch of BCBAs and BCBADs at Judge Rotenberg Center. The question that keeps coming to mind is, how are these people not having very serious consequences under our ethics code? Because it's very clear that there's a continuous stream of violations that are happening of our ethics code on a whole slew of areas. Now, am I saying that the conversation that those behavior analysts had is the same as the human rights violations that are occurring at Judge Rotenberg Center? No, they're not the same. But there's a pattern of behavior occurring. There's a history of behavior occurring. And when it comes to the way that the BACB is handling this, by basically saying, well, we can't do anything because free speech, that's concerning to me. What's also concerning to me is that the last 2 elections that we've had for the BACB board positions have been forced choice. I can tell you right now, in both cases, I did not throw my hat into the ring. I just want to point that out. Did not throw my hat out in the ring. But in both cases, I know that there were at least 5 highly qualified individuals, most of whom are neurodivergent, as well as behavior analysts with many years of experience, who put their hat into the ring for the elections. And what we got was a forced choice, which is just keeps bringing over and over issues and concerns that I have. When we're talking about power dynamics, the BACB at the end of the day is a corporation. And if you look at the minutes of the BACB board, it seems like they're more interested in profiting and expanding than they are in maintaining our ethics code. And I'm very concerned about this. And every BCBA, BCBAD, BCABA, and RBT should be concerned about this. Because ultimately, we need to hold our board accountable. They need to hold us accountable too. If we violate our ethics code, we need to have consequences, and we need to have ways of addressing these things. Again, I'm going to say this again, because it bears repeating. I do not think that the certificates who had the discussion about genocide and mass incarceration should have their certifications removed. I believe that they need to be required to do mentorship, so that way they can learn and do better. And only if they do not follow through with the expectations should licensure removal be put on the table, because ultimately taking their licensure can heavily impact their livelihoods and well-being, and that is not okay. That's a very extreme move and should not be made lightly. And there needs to be accountability. And there needs to be consequences. And if you're worried that speaking out and giving your concerns and stating your concerns about the BACB's action in this particular circumstance are going to be resulting in you getting an ethics code violation for as a result of this, just keep in mind that in the case of NLRB versus Pier 60 LLC, I forgot to cite the court case, I'm so sorry, 855 F3D115, so that's the Second Circuit Court in 2017, that ruling. We are protected in our ability to engage in that criticism as long as we're not engaging in harassment, because BCBAs do not engage in harassment, right? As long as we're following through with our ethics. So it still applies to us. We got to make sure that we're being responsible, accountable in our own behavior. I am appalled that we even have to have this conversation. I'm not even that experienced of a BCBA, you all. I've been certified since 2020. And yet, the reality is that our field is a field of peers. You're my peers. The board members are our peers. The reason the Behavior Analyst Certification Board was formed was to create accountability, so that way we were not causing harm. This was due to a long line of issues that were occurring that culminated for the initial accountability and organization with what happened at Sunland, where there was some very serious abuse that happened by somebody who claimed to be a behavior analyst but had not gone through the proper training. And so that's why the BACB was formed. And this is also one of the reasons why I heavily, heavily, heavily encourage all of you to also consider certifying with the International Behavior Analysis International Behavior Analysis Organization, IBAO. If you go to theibao.org, I believe, if you're already a BCBA, it's $50 and you prove that you're a BCBA. It's really not that hard to do. I highly recommend checking it out. I've heard some good things about the quality behavior analyst certification as well, but I have not dove too much into that. But I will say that for the IBAO, you would become an international behavior analyst, IBA, and the IBAO is working to try to make sure that we're supporting behavior analysts outside of North America, specifically Canada and the US. So your $50 for that, even if it doesn't have an immediate benefit for you, it actually helps with dissemination and supporting of behavior analysts outside the US. Because when the BACB pulled their support from the rest of the world, basically, there were quite a few behavior analysts or behavior analysts in training, some of whom I know personally, who were basically left out in the cold and were not able to get a certification or licensure that was recognized around the world, and the IBAO is working on doing that. The benefit to supporting this organization also is that it decentralizes power. It decentralizes power. And right now the BACB has demonstrated that they need to have competition, and we need to have some decentralization of power, because they're not willing to follow through with their own ethics code and enforce it in a case of very clear violation. And they would rather say, well, free speech, than do the work necessary to ensure that we're protecting our clients first and foremost, and secondly, protecting our field. When the proposal for the American Medical Association to basically ban behavior analysis as a recommendation came through earlier this year by students, a lot of people went, oh no, it's fine, because they changed it to just evidence-based. And so, crisis averted, we're good. When that happened, my thought process was this: if students in the AMA are making this proposal, this is writing on the wall for us. We need to change our field. We need to change what we're doing. What needs to happen is there needs to be accountability, not just for BCBAs, but also for organizations, because the reality is that organizations such as, I believe CARD, and there was a few others out there, where they just dropped clients and left them without following the ethics code. Their entire thing was, well, we're not BCBAs, we're just an organization. That has some very major ethical implications, because what happens to those BCBAs? They're the ones that are ethically required to make sure that proper transitioning occurs. So does that mean that if a corporation decides to behave unethically, and then a BCBA is working for them, that the BCBA is held accountable for the behavior of the corporation, even though the BCBA is working inside of coercive conditions? Because I'll tell you right now that those BCBAs who are working at those companies, they probably didn't, voluntarily agree to those sorts of things. So there needs to be some sort of accountability put into place there. And there needs to be accountability when it comes to how we speak about our clients. And the reality is that advocating for or having serious discussions, especially outside the context of a classroom, about mass genocide and mass incarceration when referencing the people that we serve, it's unacceptable. I feel like I'm kind of going around and around in circles at this point, so I hope this is good information for you all. I am going to be doing additional research and hopefully publishing or posting something in relation to case law, because there's a lot more. Those were just the brief notes that I was able to pull up from my master's course. But know that when it comes to case law and free speech, there is no protection, because for what was said, because as behavior analysts, we're voluntarily a part of an association, and licensure is contingent on us following the ethics code. Contingent. Your behavior mentor on Instagram earlier, shout out to you if you're watching. Thank you so much for posting this, because that's was the antecedent for me for doing this video a little bit sooner than I was originally planning on. She posted something along the lines of realizing that you could lose your license for accepting an $11 gift, but people can have a conversation about genocide and be protected by law. That was the catalyst for me jumping on tonight and doing this live, because the reality is that it's not protected by law, because there's case law that indicates that if you're in a professional association or you're working for an organization and you have a choice being here, that your words matter, what you say matters, and there can be consequences for them. Now, can the BACB remove your licensure for saying the F-bomb or cussing someone out? I mean, if you're engaging in harassment, probably. I would definitely think that unprofessional behavior that's harassing would be appropriate to have some sort of consequence in place. And, at the same time, free speech like criticizing the BACB and saying that this is unacceptable, that is protected. But when it comes to our ethics code and all the different areas that our ethics code can be cited, I can't even recall all the different ones, but there's at least 5 or 6 points in the ethics code where that conversation that was published publicly for many people to hear, and that has been harming our field, but not just harming our field, more specifically pushing us back, what, almost 100 years? Like, I thought we resolved this back in, like, the 1940s, 1950s, right? Come on, people. Like, mass genocide and mass incarceration as it relates to people with disabilities is not okay. It's just not okay. And inside of a professional organization such as behavior analysts, we should not be having conversations like these in that flippant manner and outside of contexts where we're considering it from the ethical standpoint. I hope you all have a good night. I hope that your voices get loud and we can maybe possibly change things. The reality is that we do need to be careful with how we talk. We need to be careful with how we treat each other, and we need to be respectful to each other. And we also need to put our foot down and stand up. Because this hurts all of us. It hurts all of us when people make sexist, racist, homophobic, xenophobic, ableist statements, and there's just no reason for us not to say something or do something about this. We're in this together. Human first and human always. Y'all have a good night.